right, welcome back to the podcast, HOA Hell. I'm Michael Kushner, your host. With me today, as usual, is Senior Associate from MBK Chapman, Sam Kill. Sam, hi.
Hi, Mike. How are you?
I'm fine, thanks. Glad that you're here with me today.
Thanks for having me.
We're going to handle something that is becoming more and more common and more important in Southern California, or even just in the state of California, given we're the Sunshine State.
Right.
And that is solar.
Mm-hmm.
We're going to be handling solar. And basically the question we're going to be dealing with today is, can your HOA stop you or prevent you or hinder you from going solar? And what does California law say about it? So we're going to cover all aspects of that today. Mm-hmm. We're going to kind of divide today into two. We're going to start with single-family homes or townhomes that are not classified as condominiums. And then we're going to move into condos, okay? Because it's completely different with condos. When you don't own the roof, you just own a portion of the roof, right? Mm-hmm. And you don't even own a specific portion. You just own a pro rata portion.
Right. Exactly.
So we're going to handle that today, okay? That's what the episode's about. Now, before we jump in, I want to make an important distinction. There is a difference between the ability to regulate and make sure that things are being done correctly and the inability to ban, okay? Just I want to do a bright line here. The California law on solar power makes it very clear that HOAs can't stand in your way of installing solar, okay? Mm-hmm. But they can require certain things, and we're going to be covering those today, okay? Right. So with that out of the way, let's talk about the legal landscape. And again, we're going to start with single-family homes, and then we're going to move into the multi-unit housing. Mm-hmm. So there are two statutes, Civil Code 714 and Civil Code 714.1.
Right. Mm-hmm.
Those are the two that control the Solar Act, right? Mm-hmm. Okay. So 714 basically states any provision in your governing documents that somehow works to ban effectively or outright solar power is void.
Right.
Okay?
Mm-hmm.
That's easy. And it also applies or extends further to not just banning, but restricting so much as to be an effective ban. Right. Okay? Mm-hmm. So significantly restricting is also void and unenforceable. And the law goes further. It defines what that means. So there are two examples of that. Mm-hmm. Give me one of them, Sam.
Okay. One of them is if the prohibitions or restrictions in your governing documents extends to possibly reducing the output in your solar panels by 10% or more.
Right. In other words, if the rule that they want to enforce against you, and it wouldn't apply to a ban because a ban's a ban.
A ban is a ban, right.
Okay. So this is restrictions, okay? And significantly restricts is the term used in the statute in 714, and that's defined as there's two factors to it. He gave one of them, or two examples. He gave one. If what they're trying to push on you will reduce the output by 10% or more, they can't do it. Now, if it'll reduce it by 5%, conceivably they could, if it was otherwise reasonable.
Right.
Okay? If it's unreasonable, even if it's 1%, they can't do it. Okay, that's the same with any rule. It has to be reasonable. But let's assume reasonability, okay? So they can't reduce your output by 10% or more, okay? And the second one is if what they are asking you to do is going to increase your costs of installation by $1,000 or more.
Right.
Okay? So those are the two. Significantly restricts means it'll increase cost by $1,000 or more, or it'll decrease output by 10% or more. If it is either or both of those, it's going to be void. Okay? So last thing 714 does, for the most part, is it makes it very clear that if it makes it very clear the HOA has 45 days to look at your application. And if they fail in 45 days to act on it, either reject it or approve it, if they do neither of those, then it is deemed automatically approved, okay, which is a very nice provision to have. A lot of governing documents actually have that for any improvement with a certain period of time, 30 days or 60 days or whatever. I like the CC&Rs that do contain clauses like that. But here it's built into the statute, so it doesn't matter what the governing documents say. It doesn't matter if the governing documents say they get 60 days. No, they don't. They get what the statute says. It doesn't trump. So if they do nothing, if they lose it, sit on it, ignore it, and 45 days passes, on day 46, it's approved. You go ahead and do what you want, okay? That's black letter law, folks, black letter law. Now, we'll talk later about 714.1. If we have time, we'll get into that when it's relevant, but right now it's not. So that's black letter law. Now, what do HOAs tend to do? And you're seeing this less and less as solar becomes more ubiquitous throughout the state. You're going to see this less and less, and it'll decrease, I think, every year. But these are still things we see. Some of the games that we see, what kind of games are HOAs playing when it comes to people's solar power applications?
Well, in simple words, they drag their feet. They delay. In which case, the 45-day rule is fantastic.
Right. But so let's leave that one out because they can only delay so long, and then they're out of luck.
They will basically poke at your application and say it's incomplete, missing stuff, ask you to submit addenda, supplemental information.
Which you're not obligated to do.
Exactly. Or probe into things that really goes outside of the purview of what you're required to provide legally.
That's right.
And so
we'll talk about later, didn't interrupt you, we'll talk later about what a proper application should look like. And if your HOA is demanding anything else, then I would push back.
Yeah.
Because they're playing games.
And unfortunately, that discourses a lot of people, right?
Where I was looking for was they lodged some sort of vague aesthetic objection.
Oh, yeah, the aesthetic and harmony objection is huge.
Because panels, some of them can look really cool and sleek, but some of them aren't.
Right.
Okay? Some of them are not as good looking as others. Some of them might be a little higher. Okay? But guess what? Doesn't matter.
Right.
They cannot lodge an aesthetic objection on a solar panel.
Right.
Okay? They also can't say, well, you know, if you have it on the front part of your roof here, everybody can see it from the street, so we want you to put it over there. That's not how it works. The people installing it are the ones that know where to put it based on where the sun shines.
Right.
Okay, so if they try to object on an aesthetic basis and have you reposition so that you're going to lose efficiency by...
That's a big one, by 10% or more.
Then you can't do it.
Yeah.
They can't ask you, for example, and this is not the common, I mean, this is obvious, so it's not so common, but if part of your roof in the back where nobody can see it happens to be in the shade part of the day, they can't say, put it back there instead, we don't want to see it. Right. Too bad. They're here to stay. Get used to panels.
Yeah.
And so if they ask you to move it to a less efficient place, as long as it doesn't cross that line of 10% efficiency, which is actually not a lot, so it's actually a very good rule for you, then they're going to be out of luck. I don't care about aesthetics, frankly. The law says, too bad. Get used to it. Okay?
Yeah.
Don't cry. Delay tactics, though. You gave them that. But that's short-circuited by... Yeah, they can wait 40 days. They can wait 43 days. But 45, they can't, okay? They do a bait and switch on placement demands. They insist you put panels or less panels here and more panels here. Again, that won't change probably unless it's in the shade. That won't change the power output. But if your installer says, look, it's going to affect, well, I guess it could, right? I guess if they tell you we want to minimize street side, and they ask you to put more in a place that doesn't get as much direct, it could at some point hit that temperature.
But again, a board member being a layperson
doesn't have
versus someone who is basically an expert, a consultant, or does it for a living or routinely, and then will it affect warranty elements? I mean, we don't know.
Right. And you're the solar people, the legitimate, reputable solar companies. They know all of this. This is they are very good at what they do. They'll put together your complete application. They'll do all that for you. They know what is required. So I would yield to them. They know what's best. They have a reason why, if you're getting 20 panels over a certain period of space, why 10 are here and 5 are here and 5 are here. There's a reason why they're doing it that way, the way they're clustering them. It could also be roof issues too.
Exactly.
It could be load on the roof, weight-wise, or how many holes, penetrations. I don't know. I'm not a contractor and I'm not a solar guy. But they know. And so it's very difficult. An HOA would have a lot of difficulty trying to countermand them for some vague aesthetics thing because the law already says take your aesthetics and shove it. So good luck with that, okay? Sometimes these HOAs, let's say they ignore your application for 45 days, and then you go ahead and install it, and then they try to fine you afterwards. They do that a lot. That does happen. Or they try to claim, well, we weren't going to act on your application until it was complete, and it wasn't complete. Well, too bad. It's not what the statute says. So they try after the fact. That's what they do. And there isn't much more beyond those 4 things that they can really do.
Not really, yeah, no.
But they try. They do try.
There's a lot of crossover between those as well.
It is, yeah. So here's how you build a legally defensible application. Okay, first of all, again, if you're dealing with a reputable solar company, they're going to be very experienced dealing with HOAs because HOAs are everywhere in California, so they're going to know how to do it. They're going to probably ask you for a copy of your architectural guidelines if they exist and for your CC&Rs. They're going to ask you for that because they're going to go and compare them to what they're expecting to see and modify their plans accordingly. Part of what you're paying for is that service.
Right.
They know, for example, that they've got to come up with a CAD drawing of, make a mock-up of your roof and put lay out the panels, because there has to be one of the things that makes up the application is a set of pictures that'll show what your panel layout's going to look like.
Right.
And how many are going to be on there and where they're going to be on the roof. So there's multiple ways to do that. You can do it with CAD, or let's say you did they did another house, your next door neighbor, or another house in your neighborhood with the same model. Sometimes they'll use the pictures from that roof. They can do that too. That's perfectly fine. But either way, they'll prepare that for you. You don't have to do that. Okay? They're going to put together, so not only that panel layout, but and panel placement sheet. It might be more than one or might be one. But also they're going to put together a package that includes a copy of their license, their installation license, because you have to be licensed in California to do this sort of work. It's like any other contractor. They're governed by that. They're going to notate any other specific permutations of your governing documents that have been upheld, and they'll make sure that they comply. They'll put together your package for you. They might even submit it for you. My solar company did. They took care of everything. I didn't have to submit it. I just had to let my neighbors know. Out of courtesy, I let my neighbors know, and they signed off.
Yeah.
Even if they didn't sign off, it wouldn't have mattered. But it's a courtesy thing, so you do. Okay? And they like doing that because it's how they can say, hey, we're working with your neighbor over here doing installation. While we're at it, would you like us to do yours? That's how they get business. So they don't have a problem doing that for you. But in my case, I did it. They will, if your HOA pushes back with repositioning of the panels or anything, they will prepare the report for you that shows if it does cross the line of the 10%.
Right. The impact, yeah.
Or the $1,000. They'll give you an amendment to give back to the board as a response. It says, au contraire, you're over the legal limit here. Either this will reduce, in our opinion, because this is where it's 22% more shade over here over an 8-hour period of the day, and this will reduce the output by 12.77%. They're the ones that have that number. Your HOA can't argue with that number unless your HOA goes out and hires a solar expert of their own, which will cost a couple $1,000. They won't do that. They have no answer to that. So if your solar people say, we got pushback over here, but we're going to submit this for you that tells them it's going to be a 13.62%, your HOA is dead in the water. They can't do squat.
And by the way, that's usually not phony math. They have to stand behind their work.
And they do.
So the production output estimate has to be somewhat
They're not going to lie. The legitimate ones they're
Right.
going to tell the truth, because if it's less than 10%, it won't matter. They won't care. That could have been their aesthetic, right? And the HOA can impose its aesthetic as long as it doesn't cross the $1,000 or the 10% line that we talked about before. So they'll put it all together for you. Now, to the extent that your HOA pushes back, it's going to be in writing. If it's not, tell them, I'm not going to talk to you about this, put it in writing.
Yeah.
Okay? But that probably will certainly not happen. In which case, your response needs to be in writing. Everything. Even if you get on the phone with somebody, follow up in writing. Always, always, always writing. Okay? And calendar your 45 days. If I were you, and whether or not your solar company's submitting the application or you are, once they prepare it and give it to you, either way, my recommendation is that you send it in one of two ways. Certified mail return receipt requested, or hand delivered to the management company or whoever, typically management company, with a signed receipt saying that they've received the solar application. It's got to be that. You can't just hand deliver it and say, oh, I gave it to Brenda,
Right.
or I gave it to Marshall. You need to say, I gave it to Brenda or Marshall at this time of day, and then have them give you received, okay? Now, if your solar company is the one doing it, make sure you let them know, and I would do it in writing, but let your solar company know that you insist that they send it in certified or hand delivered with a receipt. Yeah. The reason for that is you do not want them playing games with regular mail, okay, or any of the other games they like to play, and there's no way to prove that they're lying. You could know to the bottom of your heart that they never dropped it in the mail, and there's no way to prove it, so the law's going to side with them. So avoid that, get proof of delivery. Okay. And then set your calendar for day 46. Because if you don't get a response within that 45 days, on day 46, your install people should get up on the roof and start installing. Okay. And I would actually schedule an install date tentatively. I would do it like 10 days into the thing, depending how busy your company is, just so you get on the calendar there. But make sure that whoever's doing it is doing it the way we just talked about.
Yeah.
So that there's no shenanigans about anything, okay? Now, let's assume for a minute that things go south and your HOA takes the position, regardless of what your installer said, regardless of what your solar expert said, they said it's going to be 13.7% degradation in output, and your HOA says, nope, we're still banning you. What do we do, Sam?
Well, that would clearly run afoul of the black letter law of the statute. And at that point, I would say you have a couple of options. You can request an IDR.
Okay.
Short for Internal Dispute Resolution under Civil Code 5910.
Okay, so internal dispute resolution, we've talked about that before. Just I'll let you finish, but let me reiterate what that is to everybody.
Yeah.
It is nothing more than a request by you in writing. Under the statute, it has to be in writing. Yeah. And then your HOA can't deny you, okay? And you will then be able to have a physical sit-down or a Zoom or phone sit-down, either way, with one or more board members to discuss your beef. In this case, why are you denying me when California law clearly supports my right to do it? And I've established with my expert that this is going to be beyond the 10%.
Right.
You are not legally allowed. That's what that IDR is about. Do you have to do IDR, though?
No, you don't.
If you're a homeowner?
No,
the HOA does if you demand it.
Correct.
But you don't have to.
Exactly.
What if the HOA demands it? Do you have to?
No, you don't.
You don't. It's a one-way statute.
It's not compulsory.
Okay.
Yeah.
So that's one thing to do. Let's say either you know that they just don't like you on the board and they're just screwing with you.
Right.
So you know IDR is going to be a waste of your time.
There's really no point to it at that point. Yeah, exactly.
What's the next option? Or IDR doesn't work. Either way, what's your next option?
Well, the next option that we would recommend is that you come and see us, here at MBK Chapman. But basically, statutorily, your next recourse would be to serve them with a request for resolution under Civil Code 5930, which is an ADR demand. And
a formal ADR demand, which we recommended
in writing. Yeah.
You have done by a lawyer. And it's got to be a lawyer trained as an expert in the Davis-Sterling Act, not just a real estate lawyer, not just any lawyer.
Right.
That's why we recommend us. We are the best at what we do. Taking even larger competition of ours into account, I'm the one that trained the shareholders of those law firms. I'm the one that trained them, and the systems they use are the systems that we use at our firm that I taught them to use for HOAs. So you come to us, we'll do the ADR demand for you.
And as we've covered more extensively in other episodes, it can get very technical. So it's absolutely paramount that you get your documents together and come to us so that we can organize it and synthesize into something that gives you leverage.
Right.
Yeah.
All we need from you in this type of scenario is your application and any correspondence from the HOA pushing back, and then any response you had, and then their denial. We'll take it from there, and you're going to get your solar panels. If your solar company was a legitimate installer and purveyor of solar panels, and most are, right? There are. Make sure they're licensed. You do your due diligence. Don't just, if somebody comes knocking at your door, that's okay, but check them out. Look on the internet and check them out. But assuming all is on the up and up, they're going to, if your application was submitted and prepared by them, the HOA is going to be in the wrong here. I mean, it's really that common. This is not a difficult issue. They make it. HOAs make it difficult because they have egos and you have people on the board that are just, well, we'll get into their psychology in the future when we do another episode.
I mean, the law and public policy here in California makes it very clear.
Very clear.
Yeah.
Okay? So, IDR first or not, it's up to you. And then ADR, but through us. Okay? Now, if that doesn't work, if somehow your HOA is just insane and is ruled by dumb dumb people. And by the way, we litigate cases all the time with this exact scenario. Dumb people who are going to end up paying us and our clients 10 times more than they could have gotten out for it in the beginning. But it happens. So I'm going to talk to you about it now, even though it should be impossible to conceive of it happening. It does. I promise you it does. Even something as bright lined as solar. So it will happen once in a while. So then we sue. And we sue for deck relief. We sue for injunctive relief. We sue for damages.
Yeah.
And we sue for attorney's fees. So let's talk about each one of those. We've talked about deck relief in the past. You're asking the court to declare the rights and responsibilities of each other. In this case, it would be something along the lines of, we have a right to install these solar panels as applied. The HOA has the obligation to allow it and no right to stop us. Tell them that. That's what that is.
Exactly.
That's what we're going to do. Okay? Injunctive relief is an order from the court saying, don't stand in their way. They're going to install these. Get out of the way. That's the injunctive relief. Damages, if you've lost, let's say there was a special deal going where, if you installed in a certain month, let's say it was the winter or something, you got 10, 20% discount and that's gone because of the delays. They're going to owe you for that. Or let's say by the time you guys get through with all this, prices for those very panels, the same ones you applied for, have gone up 30% because there's a tariff now or whatever. Guess what? HOA is going to be liable for that difference.
Right.
Okay. So for whatever reason, if you've got increased cost or lost opportunity, those money damages are going to be the responsibility of the HOA. And finally, under multiple sources, you're going to be entitled to your attorney's fees upon prevailing, and you will prevail, and you're going to get your money back. And judges don't like when HOAs stand in the way of public policy things like solar power or EV charging, stuff like that. They don't like it. Okay. So that's how we're going to do it. So now let's do a shift. We've been talking about single family homes this whole time. Okay. In a single family home, it's real easy, or in a townhome that's classified as a PD. Okay. Where maybe one or two people own the roof. Okay. It's a very simple thing. In my house, I own my house, I own my land, I own my roof. It's on me, right? Now let's talk about condos or townhomes that are classified as condos. Multi-unit housing, whether it's a high-rise or a bunch of buildings, with 4, 6, 10 units each, doesn't matter, okay? Law is a little different. Same public policy, solar good, solar good, solar good,
Right.
Okay? That's the public policy. Alternative fuels, good, okay? Climate change, bad. That's the policy. So same policy, but there are some differences that you have to recognize. For example, pretend for a minute that my open folder here is a condo roof. And under this condo roof, let's say there's 3 stories of condos and there's 25 homes. And let's say there's multiple buildings in this community with buildings just like this, but we're going to isolate this one roof. So this is one of the condo buildings with 25 units in it made up of 3 stories. Not that the units are 3 stories, but they're each on 1 story, but there's three stories of units, okay? Now, I, as a condo owner, we talked the other day about condos. We usually own the air inside, the paint in, right? That's our space. But we don't own the exterior. We don't own sometimes the windows. We don't own the stuff inside the walls. And we don't own the roof, but we own a portion of the roof, but not a specific part, not this part right here. That's not mine. Everybody owns the same portion of every part of the roof. So it's not like we divide the roof by all of us and this one's mine, this one's his, this one's hers, this one's hers, this one. That's not how it works. We all own all the portions.
It's in common and pro rata.
Exactly. Okay? So, I obviously, let's say my unit's under here, okay? I obviously can't go and put solar panels over the whole roof and then start banking power and selling it back to the city because I'm taking the whole roof. I can't do that.
Right.
What the law basically says, and this is where 714.1 comes in, okay? Also, by the way, not as accurate about that. Actually, it's more so 4746. So let's go with, I'll do 714.1 later. 4746 of the Civil Code, Davis-Sterling Act, is what kicks in and says, okay, we love the Solar Act, that's all great, but when it comes to condos, here's some additional laws that will counter some of what we said before, okay? And one of those is that condo owners absolutely do, yes, 100% have a right to utilize a pro rata fair share
Right.
of the common area roof. In this case, my folder here. Okay? So if there are 25 homes, oh, by the way, let's pretend, just for the sake of this example, that all of this is in the sun.
Oh,
Let's pretend none of this
point.
is shaded.
Yeah.
Because I don't want to do the math, to be honest. So
Right.
I just want to make it as easy as possible for me. So this whole part of the roof is always in the sun. Okay? If there's 25 homes, then I would be entitled to a space equal to as if I gridded this by 25 and divided the roof. So whatever that turns out to be is what I'm entitled to. Okay, I can use that much space. Now, there are a couple of conditions. Condition number one, can you give me one of those conditions, Sam?
Well, the condition number one is that you're willing to enter into an agreement with the association, and that's typically referred to as one of the following: either a covenant, a maintenance and indemnity agreement, or a maintenance and repair agreement.
I want you to start with that one. Tell me what that is.
Well, that's basically you're saying that, look, association, I have a right to install this on my pro rata share of the shared common area roof. And in exchange, I am taking on the repair and maintenance obligation of this, which will be recorded by way of an agreement or covenant against the property. So everyone, current, present day, and prospectively, will have constructive notice of it. And it will run with the land, meaning that I or any successor or transferee will promise to maintain.
But what is a maintenance and indemnity agreement? What am I saying I'm going to do?
You're saying that you're repairing, maintaining, if there are any holes that are made into the common area or shared roof, you will be responsible for repairing those. If you basically take anything out, meaning you, let's say, pull out or uninstall any of the panels and there's any subsequent damage incurred, you're responsible for fixing those.
So in other words, what Sam is saying is in entering into this maintenance agreement or a covenant, you are basically saying to the board, okay, to the extent I'm allowed to pierce and go into our common area roof, even though I don't own this, okay? I own it in conjunction with everybody else.
Right.
But in return for that, I'm being permitted, in return for being permitted to pierce that roof and utilize it, if my installation, if my panels cause any leakage to somebody's unit, the HOA is not going to be responsible. I'm going to be responsible. The HOA is not going to be responsible for paying for the repairs. I'm going to be responsible. If if my negligence in doing so results in damage to somebody's personal property, then I'm going to be responsible for that. Okay. Now, if there's a leak and I wasn't aware of it and it damages personal property of somebody else, I'm going to be responsible for repairing just like an HOA would, but I'm not going to be responsible for personal property, most likely. Not unless there was negligence on my part. It's the same rule. But you're taking the maintenance and repair obligations off of the HOA's plate because it's a shared roof, and you're taking it on yourself. But not the whole roof, just my part, the part I'm using. Okay? So that's number one. They're going to almost certainly require that, and they have a right to, and you'd have to agree to it, or they don't have to give you the roof.
Right.
Okay? Number two, you can't, to the extent that somebody else is got panels up there already, if installing your panels is going to diminish their output, their ability to use their panels, you can't do it. So your impact on other people is going to be taken into account. Now, if you're the first one, that won't matter. Okay? Another thing is, and this gets into I don't know how this started, to be honest with you, but there is a very, very, very common misconception out there. And non-expert lawyers in this field even spout this, and it is just wrong. I don't know where it came from. But if you could even Google this, and you might even get some wrong information on the internet. But somewhere floating out there in the ether is this concept that the part of the roof you're using has to only service your unit. Like if it's got vents or something from somebody else's unit, you can't do it. It can only, or it has to be directly above your unit. That's not true. That's just ridiculous. If you're on the first floor, or the second floor, that 3-story condominium complex under here, it's absurd. Okay, that's not in the statute. If you go look at the statute, the Davis-Sterling Act in particular, 4746, it says what it says. It doesn't say that. Okay, but that's out there. Don't be fooled. Okay, you now have been told that is hogwash. But it's out there and it's common. I hear it all the time when solar stuff comes up. We get that question. I'm like, yeah, no, it's not how it works. Okay. I've even had lawyers argue it for not the big firms that represent HOAs, but people that were hired by a small HOA and they fancy themselves HOA lawyers and they're not. And we've got it from them and we write back. I mean, I'm tempted to send a GIF that, of somebody laughing because it's just so wrong. But anyway, and I have done that once. But as long as you're willing to sign that covenant or agreement and maintain a reasonable amount of insurance to secure that obligation. So, for example, your HOA doesn't have to trust that you'll be in an economic position one day to abide by your maintenance obligation, or if something worse happens, real damage, they don't have to rely on that. They can say, we want you to insure on that, so that if it does happen, we don't have to hope that you're employed at the time or you're not in between jobs. We want you insured. So they can require you to have insurance policy in place that will cover this specific adoption of maintenance obligations and repair obligations.
Right.
And make them a secondary insured and give them notice if there's ever a lapse in the policy. They get notice. For obvious reasons, and that's reasonable. That makes total sense.
I mean, in many ways, you're stepping into their shoes for that pro rata share of the roof.
And they have a right to make sure that you're stepping into the shoes properly.
Exactly.
So they can ask you that, okay? And other than those three things, the maintenance, the insurance, and the indemnity.
Well, there's one that goes without saying, but this is a reasonable way of regulating this, and that's requiring licensed contractors and installers.
Yeah, that goes without saying. You can't. You're not allowed to do anything.
Right.
Technically, okay? So we'll do a different show about contractors' licenses in the future. Everybody has to be licensed where a license is required. Otherwise, you're violating the law. You are guilty of a public nuisance, okay? If you are utilizing unlicensed contractors anywhere, single-family home, condo, doesn't matter. So no, there's only three obligations here, or three requirements that they can impose. One, well, four if you count the fact that you can only use your pro rata share of the roof, okay? And you can't interfere with somebody else's use. But the three things that they can require of you is the maintenance obligation or the covenant, which will usually go hand in hand with an indemnity. It'll all be in the same document, but you indemnify them, meaning if they get sued for what happens, you indemnify them for that. And then you have to have sufficient insurance to secure your obligation, okay? In practice, if you're a condo owner, you want to, when you do your request, and again, your solar company will get permission, because you do have to get permission to let them up on the roof because it's not your roof. So you'd have to submit a request ahead of time saying, I want my solar, I'm hiring a solar person to go up on the roof and look at the roof and come up with a plan so he or she can do the calculations to figure out what I'm entitled to and where it might go. They have to allow that. They can't, because that would be them, if they said, no, we're not going to allow, he's not our vendor, we're not allowing him up on the roof. Now they're standing in the way of public policy because they're doing an end run around the statute. They can't do that. You have to ask for permission, but they have to grant it. And they're going to want to see the license and all that. But once you submit that, and your expert will know that and already have it ready. They'll go up there, they'll do the calculations, they'll say, okay, here's the roof, and this is where we want to put the panels right here. And this constitutes X percent of this roof, which is your pro rata share of that roof. And then they'll tell you and put together the application how many megawatts or whatever it is that they do.
Kilowatts, yeah.
Kilowatt hours or whatever it is. I'm not an expert in this at all. I just have one. I know it. It's there and it saves me money. But they'll take care of that for you. But that's what they'll do, okay? They are not qualified, okay? Your solar experts are not, no matter what they might tell you, because they could have seen 100 of these. They are not qualified to advise you on a maintenance and indemnity agreement. Do not look to your solar people to help you understand the agreement or whether you should sign it. That should be a lawyer and a lawyer only, preferably an intelligent, competent lawyer. There's a lot of them out there that are neither of those, okay? Now, when you submit your application, and again, your solar expert will tell you all this. They'll give you a list of what you need to give them if they're going to do your application. They're going to say, give us a copy of this insurance policy, give us a copy of this. I have the site plan, I have the pro rata calculations. They'll ask you for what they need. Just give it to them, okay? And then they'll go from there, and they'll take care of it for you. What the HOA can't do is say, no, it's a condo. You don't own the roof. Goodbye. Can't do it.
Nope.
Okay? So the bottom line is everybody has a right to install solar panels. Now, obviously, I have a right to install a lot more than a condo owner might be because I have more space on my roof and I own 100% of the roof. Depends how many units are in your under that roof there, right?
Yep.
If you're in a building with 4 units and it's a big roof, you might have all your energy needs anyway with a quarter of that roof. Now, the calculation does change when, let's say, this is the roof again, but let's say this portion over here is in the shade for a good part of the day. Well, when you are calculating the usable parts of the roof, you exclude that. So the solar panel, you're only going to be entitled to your pro rata share of the part that's usable. So that will shrink everybody's down. But that makes sense because you can't allocate the last person to ever do it.
Exactly.
Well, you're in the shade, buddy, so you're going to end up with 0 kilowatt hours.
Right.
That wouldn't be reasonable. So just keep that in mind. If there's a portion of your roof that either doesn't face the sun or is in the shade because of foliage or whatever, your expert was going to know that. That goes into the calculation on this total square footage of the roof. And then when they do the calculation, they have to exclude the non-usable portions. So everybody's pro rata share will shrink. That's just normal, and that's the way it is. Right. Damages for failing here are the same as they are what we were talking about before. It's the same remedy. There's no difference.
Right.
Okay? Now, obviously, he said this before, use a licensed contractor because if you try, you won't get very far because they're going to want to see the license anyway. But and maybe in a different show, I'll explain the legal dangers of not using a licensed contractor. You don't want that to happen because then you become, under California's employment and labor laws, you become an employer. And that is a whole bunch of liability that won't be covered by your insurance. But you're going to get an energy, when your solar people come and advise you, when they're coming up with your plan, you're going to get an energy output report. Okay? So you're going to get an energy output and cost savings utility report. That'll be part of, to show you, here's what because your solar company's going to ask you for a copy of your, most recent, maybe 3 or 4 utility bills, electric bills, and then afterward they're going to be able to show you what you're going to save. So you're going to get this whole thing. The HOA doesn't need to see that, by the way. It's not their business, but if they want it, give it to them. Who cares? But they're not really entitled to see it.
Right.
But you'll get a list of what your future costs over a period of a year, 2 years, 3 years, depending if you're leasing or buying or financing, paying cash, leasing, or financing your panels. You'll get a year-by-year assessment of what you're going to save and what your payments are going to be. It's all going to be laid out for you. If any of this is missing, leave them and go to a reputable solar company because this is all automatic, okay? And just remember that 45-day countdown. Other than that, folks, I hope I imparted to you, this is not hard. Your solar company will do all the hard work, all the math, all the calculations, all the stuff about kilowatt hours and this and that and energy usage and peak and non-peak. That's all of them. They are going to handle that. You don't have to do anything but sign on the dotted line and give them their check, okay? They will handle the hard part. The easy part is the law. The law makes it so easy. There's very little the HOA do can stand in your way. They can't prevent you. They can be a pain in the butt, but they can't really stand in your way as long as you're complying with the law, and the law is very generous. However, if your HOA pushes back, come to us at MBK Chapman, and we'll hold them accountable for you. I hope you enjoyed today's episode. If you did, we'd love you to hit the like button. And if you haven't already subscribed, please subscribe to the channel. Until next time, have a wonderful day.